Hello, everyone. Welcome and thank you for participating in our Tribunal Watch Windsor Law webinar series. This is the second webinar in our series called The Principles for Adjudicative Tribunals and Administrative Justice. My name is Laverne Jacobs, and I'm a law professor and the Associate Dean, Research and Graduate Studies at the University of Windsor's Faculty of Law. I'm also a member of the Tribunal Watch Ontario Policy and Advisory Committees. I'll be moderating today's webinar, which is on tribunal competence and expertise, and I'm delighted that you're able to join us. I'd like to take a moment before we begin to acknowledge not only the traditional lands on which we are holding this event today, but also and more directly the trauma currently being experienced by Indigenous communities in Canada. In light of the recent tragic news relating to the former Kamloops residential school, I think we need to pause and to reflect even more deeply on the residential school legacy in Canada. We hear from members of our Indigenous communities and can observe ourselves that this trauma has had an impact in many ways, directly, nationally, and intergenerationally. Our territorial acknowledgement gives us the opportunity to recognize that Windsor law, excuse me, sits on the traditional territory of the Three Fires Confederacy of First Nations, which includes the Ojibwe, the Ottawa, and Potawatomi. And I share this acknowledgement broadly and extend our respects to the traditional territories where you are based as well. Excuse me. I also want to mention, as I did last week, two logistical notes. If you joined us last week, this is a reminder that today's session, which is scheduled for an hour and a half, is being recorded. We will make the recording available along with the transcript that has been edited for accuracy as soon as we can after the event. Throughout today's session, if you have a question for the panelists, please feel free to place your question into the Q&A. We will have a question and answer period in the last part of the event, and we'll take questions from the Q&A box. Sorry about that. We apologize in advance if we're not able to respond to all questions, but we sincerely welcome feedback. So please don't hesitate to place your questions and comments in the Q&A. And just by way of background, for this webinar initiative, Windsor Law has teamed up with Tribunal Watch Ontario to hold these community discussions on principles of administrative justice. The effort, in large part, is related to a document created by Tribunal Watch Ontario called the Adjudicative Tribunal Justice System, Statement of Principles and Commentary. The Statement of Principles was released in May. It sets out principles that should be followed in order to ensure, enhance, and develop the rule of law in Ontario's adjudicative tribunal justice system. It recognizes four principal attributes necessary to safeguard public confidence in the administrative justice system. These attributes are independence, impartiality, expertise, and competence. The statement also emphasizes that these attributes should always be respected by governments that are tasked with adjudicative tribunal design and administration. We are using these principles as the starting point of a discussion about how to improve and reform the adjudicative justice system in Ontario. And if you'd like to read the Statement of Principles in full, please note that a link to the Statement of Principles was sent to you this morning with the Zoom link to attend this session. So let me now move right into the heart of today's discussion by giving a brief introduction to the topic of today's webinar. Tribunal competence and expertise together play a central role in the work of the administrative justice system. This can be seen from the perspectives of history, political theory, and public law realities, a term that I use to describe the litigation process. Historically, administrative tribunals were created to provide decision-making by adjudicators with knowledge of specialized areas of law that had been enacted through legislation. In light of their specialization, tribunals allowed for more effective decisions and also for the possibility of quicker decision-making, often with less formal decision-making processes. Since the time of the Industrial Revolution, which is generally seen as the point in time when tribunals first started to proliferate in Canada, administrative tribunals have grown in number. Several new tribunals were created in the interwar years and into the 60s, 70s, and 80s, as more specialized areas were identified for tribunal adjudication and sometimes diverted from the courts. Political theory shows us that the proliferation of administrative tribunals has developed with a stronger organizational plan in more recent decades. Finally, if you approach the administrative state from the perspective of those who use adjudicative tribunals, namely rights-based adjudication, such as issues relating to social benefits, and consider their journey as they engage with the system, it is clear that their experiences are ameliorated when the tribunal can show competence and expertise in handling its cases, both in relation to subject matter and to dispute resolution. In terms of how public law realities then function, competence and expertise are important on the ground for access to justice reasons. In 2003, a colleague and I wrote one of the first articles on tribunal expertise in Canada. What's interesting is that while the leading Supreme Court cases and with it approaches to judicial review have changed, some of the fundamental questions relating to the nature of tribunal expertise itself, as it exists at the tribunal level, have remained the same. These questions include how we can ensure that tribunals and their adjudicators acquire and develop their expertise, and how we can ensure that the appropriate expertise is developed for the decision-making that they do. Finally, who do we make accountable for these goals? And how do we make them accountable? What should the roles of various organs of government be in relation to tribunal expertise? For example, what should the role of the executive branch of government, the legislature, the tribunal, and courts be in our discussions about expertise? To take just one quick example in relation to the courts, should the courts be simply applying legislative will, or is there any role for the courts to articulate principles to guide the exercise of administrative discretion for the development of expertise within the administrative state? Today, we will be talking primarily about the roles of government and tribunals as we contemplate the day-to-day operational context of tribunal expertise. The Tribunal Watch Statement of Principles states the following about competence and expertise. Adjudicators must be optimally competent and the tribunal equally competent in the exercise of its mandate. Adjudicators must have dispute resolution skills, subject matter expertise, and experience in decision-making. In every webinar in this series, we address the principles we are discussing from 4 different and key perspectives. These perspectives are first, the tribunal as an institution, and here we draw from leaders in the administrative justice community who have been tribunal chairs for their reflections. Second, the perspective of those that use the tribunal. We bring a generalized view of the principle from the angle of tribunal users by hearing from leaders in the clinic community who discuss challenges that currently exist for the principle in question. Third, we examine the principle from the perspective of equity, diversity, and inclusion. Here we bring in scholars, lawyers, and individuals with lived experience to discuss and analyze the ways in which each administrative justice principle could be strengthened when it comes to fostering equity, diversity, and inclusion in the administrative state. We're of the opinion that equity, diversity, and inclusion should not be seen as add-ons, but should be relevant to everything that's done in the adjudicative tribunal context. And finally, the doctrinal law, what the case law currently has to say about the principle in question. So without further ado, let me introduce each of our wonderful guest panelists this week, who will be speaking from these 4 perspectives. They each bring deep knowledge and insights to our conversation today. These introductions are necessarily brief, and I encourage you to take a look at the much more expansive bios, which are on the bio webpage, and that was sent to you this morning as well. So joining me today is Michael Gottheil. Michael is the Chief of Commission and Tribunal of the Alberta Human Rights Commission, a role he assumed in August 2018. He possesses many years of leadership experience in the administrative justice sector, having previously served as chair of the Human Rights Tribunal of Ontario and executive chair of both the Environment and Land Tribunals Ontario and Social Justice Tribunals Ontario. Michael will be speaking to us from the perspective of tribunals as institutions. Marion Overholt is also joining us today. Marion is the Executive Director of Community Legal Aid and Legal Assistance of Windsor, located at Windsor Law. She has practiced law for 38 years and appeared before a variety of administrative tribunals and courts. Marian will be speaking to us from a tribunal user perspective. We also have Lori Mishibinijima. Lori is Anishinaabe from Wikwemekong, unceded territory in Ontario. She is currently the manager of Indigenous initiatives at Osgoode Hall Law School, where she supports the indigenization of the school and curriculum. Lori was legal counsel with the Human Rights Legal Support Center for 10 years, where she provided legal representation to individuals respecting matters of discrimination under the Ontario Human Rights Code. She was coordinator and helped develop the HRLSC's Indigenous Service, where she supported access to justice for Indigenous people. She's been a member of the Community Council, a criminal diversion program at Aboriginal Legal Services for 16 years, and was president of the Native Men's Residence Board of Directors for 7 years. Lori will speak to us from the perspective of equity, diversity, and inclusion. Paul Daly, who is on the program, is unfortunately unable to join us in person, but has provided a blog post and a short video recording of his remarks, for which we're very grateful. Professor Daly holds the University Research Chair in Administrative Law and Governance at the University of Ottawa, and is also an associate professor at the University of Ottawa's Faculty of Law. He has been a part-time member of the Environmental Protection Tribunal of Canada since September 2019. Professor Daly will be speaking to us from a doctrinal law perspective. So each of our speakers was asked to prepare a blog discussing the principles of competence and expertise and the challenges that they see from their work and experiences. These posts are available on the website, and I invite you to take a look at them. But I'd like to start off our discussion today by asking each of our speakers to present a brief overview of the challenges that they have observed. So to each of the panelists, here's a foundational question that I think we'd all like to know. What major challenges do you currently see with the concepts of competence and expertise from your perspective? And I'll start first with Michael. So Michael, you've had extensive experience leading a range of important environmental, social justice, and human rights tribunals, and have the comparative vantage point that comes from having done this work in more than one province, Ontario and Alberta. What are the major challenges that you see with the concepts of competence and expertise from the perspective of tribunals as institutions?
Well, thank you, Laverne, and it's an honor and a pleasure to be part of this conversation this morning and to be on a panel with distinguished members and of the legal community, the administrative justice community in Ontario and in Canada, and enjoyed reading everyone's blog. I should say I am on the traditional territory of Treaty 6, and the traditional home of First Nations, Inuit, and Métis peoples. I'm in Edmonton. And so to answer your question, I guess I would start with saying it seems like expertise is having a hard time these days. For about 200 years since the Enlightenment, where, the torch of authority and, it was passed from priests and religious authorities over to men and eventually women of reason. And, the idea of expertise was seen as, again, authoritative. And that, sort of lasted for a long time until I'd say just the last decade or so, where, expertise is kind of getting a bad name. If you look on the right, populists, politicians are, trashing experts as being elites and, sometimes couched in racist terms. Certainly, and that whole sort of populist notion is undermining. I mean, we can see that in the pandemic. We can see that across a number of social, economic, and political issues. And then on the right, on the left, there's also a questioning of experts, also seen as elites, questioning whether experts are, trying to preserve privilege, traditional ways, suggesting that traditional ways of knowing and understanding the world and the world's problems and our relationships, are preventing other ways, other voices of being part of that conversation. So, and then of course the courts recently with Vavilov question the importance of expertise. So, I guess I'm somewhat facetious, but only somewhat. And I'll get back to that in a minute. But I do think, whereas traditionally we would just use the words expertise and competency and sort of assumed everyone would agree with that, and somehow suggested or assumed everyone would agree generally what that meant, I'm not sure that that's the case anymore. And I think that's there's a number of problems and challenges that present when we're talking about tribunals who quite rightly are saying, look, we need to be expert and competent in our area. Now, specifically, challenges, I think you can describe those challenges, I think, in a number of ways. And first of all, the administrative justice sector, tribunal sector, is complex from a legal, public policy point of view, right? Because we know the courts have said, John Evans has said, former Justice John Evans said that, tribunals are neither fish nor fowl. In Oceanport, the court said they span the constitutional divide. Within government, there's, as members of the executive, how much are tribunals, creatures of statute? From institutional perspective, there's a range of sort of leadership and structural ways that tribunals are established, whether in clusters or at the federal level under the Administrative Tribunal Support Service of Canada and so forth. And so when we talk about challenges, I don't want to say that it's very specific, but there are, again, different aspects to tribunals given the breadth of their, and the complexity of how they're established that, makes that question itself challenging. But let me turn to sort of three points that I'll just sort of choose three things to identify for the purpose of this conversation. So I think the first thing is, what do we mean by expertise and competency? And more importantly, who gets to define those? So again, I would think that, everyone would say, yes, tribunals should be competent. As I said in my blog, anything worth doing is worth doing well. And I would say, although I agree with the Tribunal Watch statement of principles, optimally competent, we want to, superbly competent or demonstrated competence or superior competence. Obviously, we want to strive for competence, but, at the highest level. With respect to expertise, again, what do we mean by that? What falls into those categories? And I think the discussion today, particularly with Laurie and Marion, have raised real questions about, how do we think of things like accessibility, cultural diversity, and not just as an add-on, sort of that, we want a scientific specialist who has also been taught about cultural competency. What if we agree, and I think we do, and we understand, and more so in recent years, that there is systemic discrimination throughout our ways of knowing and different disciplines, whether it's law or science or health. What does expert mean in that context? And if we use only traditional notions of expertise, and if it's only traditional sort of individuals who had previously been seen as expert, who get to define what merit is and the indicia of competence or expertise, we may perpetuate systemic discrimination in those fields of study. And just to use an example, in the environmental sector, of course, I mean, we see just in the last couple of weeks where the court in Holland has, in the Netherlands, has accepted principles of the interests of future generations. That's probably not something 20 years ago that scientists or experts, quote unquote experts in the environmental sector or scientific sectors would accept as a valid principle or that people needed to know or understand. So I think there are changing. Second thing I would say is, and I mentioned this in my blog, it really, in terms of challenges to developing expertise, if we understand, and I think the statement of principles do recognize that expertise is not only the listing of competencies and attributes, it relates to appointments, it relates to encouraging people to apply, it includes professional development, but I think it also includes how a tribunal is managed and operated. And so if we see the expert tribunal as on an institutional level, we can have a broad diversity of qualifications and specializations. And that, again, when we talk about size of tribunals, can be both a challenge, but also provide opportunities. So if you have a very specialized small tribunal with only part-time members, your ability but approach to developing expertise is going to be quite different than if you have, for example, a cluster, or as we have in Ontario, or Tribunal Administratif de Québec, where you have opportunities for cross appointments, professional development across disciplines, and so forth. So I guess I would say that when we think of expertise and developing expertise, we want to remember that not only is it dependent on the structure and nature of the tribunal, but if we want to build expertise, should we be looking at those institutional structures? Should we be looking at trying to develop a cross-tribunal amalgamation or opportunities, as people have said, that there should be a professional interchange between tribunals across a jurisdiction. And finally, as I say in my blog, I think all of these things I think are important. I think the setting of competencies and expectations and so forth, but it all will ultimately depend on the commitment, not only of government, but also of tribunal chairs, the staff, the ministry, of whether there's a commitment to, everyone will say we want an expert tribunal and people with competence, but is there a real commitment to understand and provide not only resources, but real thinking about how to put together and maintain and develop over time a very strong, competent, and expert tribunal sector. And ultimately, and we'll come back to this, I think that later in the discussion, I think we as a tribunal sector need to really develop support from the broader community and communities. And those communities will be different. Some communities will be traditional, powerful stakeholders who may have an interest in competent expert tribunals. There may be non-traditional stakeholders and those without power who equally have an interest in an expert, strong administrative justice sector. We need to get solid support to drive that objective. Thank you.
Thank you. Thank you, Michael. And I think that you've raised some really important points. I want to just touch briefly on the idea of having some of that thinking done, right? So what exactly is competence? What is expertise? How are we going to implement them? And what does that mean? And I think that this third element of how we implement it, as you rightly point out, we need to have some dedication in terms of people and conceptual ideas, to lay this out and have it work. So thank you very much. I'm going to turn to Marion next and ask the same question from a tribunal, tribunal user's perspective. What major challenges do you see for the concepts of tribunal competence and expertise?
Okay, thank you so much. I share Michael's enthusiasm for this topic, and I'm delighted and honored to be part of this panel. I enjoyed the discussion we had last week, and I think we'll be able to take it to the next step. When I look at these issues of expertise and competency, I've really thought about it in kind of three categories. One being the subject matter expertise. Secondly, looking at the ability of a tribunal member to conduct a hearing. And thirdly, really looking at the awareness that a tribunal member must bring to be able to conduct a hearing and render a decision. So I think, when we talk about subject matter expertise, absolutely the tribunal member has to know the law that applies to their tribunal and that they're adjudicating on. Do they have to be a lawyer? No, but they need to be able to receive really thorough and effective training in order to understand their role and the legislation that they're looking at. And I think particularly when we talk about the tribunals that are dealing in poverty law, there's intersectionality that has to be considered. So it's not enough if you are, sitting as a member of the Landlord-Tenant Tribunal to understand the law on landlord-tenant. You also have to know about social assistance law, because in order to effectively do your job as an adjudicator in landlord-tenant, you need to understand what is happening to people who are on social assistance who may be before you. If you're issuing orders about, repayment for arrears, you have to know what the rates of social assistance are, so that, the remedies that you are applying are appropriate and can be actioned by the parties. So I think it's so important to have that real world focus on how the law actually applies to the people who are before you. That is a really critical component, and that context is vital. And that really leads me to the concern about ability to conduct a hearing. We talked last week a bit about the challenges of the digital first policy that has been adopted by Tribunals Ontario, and recognizing that holding hearings remotely is one thing, but understanding that the parties may have difficulty accessing the technology to do that, and that the relationship that the party has with their representative or with duty counsel is also affected by the remote delivery. And so they most likely have not met in person. So what does that mean for the representative's ability to really present the case in an effective manner? All those considerations are part of those procedural fairness considerations that we tend to take for granted. And it's just a little ironic to me now that the matters that we've always, commonly understood as, the right of parties to participate in the hearing, to be able to be cross-examined, to be able to make argument, all those are compromised in the presentation format of the way hearings are being conducted now. And we know that there's tremendous pressure on all the tribunals in order to address the backlog, and very concerned that as a result that we are sacrificing procedural fairness for efficiency. And so I think that, part of the challenge for a tribunal member in conducting a hearing is trying to balance those interests of the parties in terms of how they are able to participate in the hearing, and allowing that understanding of what the relationship is between the parties, right? Because where there's a significant power imbalance, as there often is in hearings before the Social Benefits Tribunal or in front of the Landlord-Tenant Board, where there may be an ongoing relationship, does the board member have an understanding of that, and understanding that the way the tribunal member presents in the hearing is very much going to affect the ability of the parties to participate. And that really speaks to my third point, which is the awareness that you are bringing as a tribunal member into the hearing. So many of our cases depend on credibility, and how you determine credibility is very much influenced by your understanding of the world and what your experience has been. And so if you haven't been, had the opportunity to gain some cultural competence, to gain an awareness of how racism and sexism and ableism and all those equity concerns, how they have impacted not only how you view the world, but how it impacts the participants before you, it is a huge concern, because all those factors really interfere and can impair a participant in the hearing. And so it's really critical that the tribunal member brings that awareness and addresses it as it is apparent in the hearing. And I think from my sense, because I just am immensely practical, it's important for people to understand, not only the history of racism within Canada, but to understand that if you're on the Landlord-Tenant Board and one of the parties is a racialized person, then that experience of racism has affected them in terms of being able to secure housing in order to maintain it, because they may be facing threats of, the landlord calling Children's Aid or calling the police or calling a third party that has much more significance given that person's experience of those institutions in the past. So to bring that kind of awareness to the actual facts and circumstances of the case before you, I think becomes really, really critical. And I think when we look at our understanding of expertise, it's so interesting to me that at my two clinics, we're teaching clinics, so we're working with law students and we're working with social work students, and so one of the things we talk about in those settings is engaging in trauma-informed practice. But I think it's ironic that we don't have tribunals that are practicing a trauma-informed practice and really looking at what the experience has been of the parties and how that affects them and how that also affects our understanding of their situation. So I think, as we're trying to defend, our basic common understanding of procedural fairness issues, there's a huge challenge for us to go forward and to do a much better job of addressing the context in which people appear before these tribunals and seeking redress, in terms of what has been their experience and what is that culture of the institution that they may be challenging, because that is also such a factor. So I think those would be the challenges that I would identify.
Thanks so much, Marion. I really appreciate your response. And, what you've raised with respect to looking at the individuals and being aware of how they have experienced and are experiencing the system, because of various, ableism, other equity concerns, but also the intersectionality of those too. I think that's, vitally important. So thank you for those comments. That's really helpful. Let me turn next to Lori. Lori, I know you've had a variety of experiences where you've assisted people from Indigenous communities in your career as a lawyer, including at the Human Rights Legal Support Center. What do you see as the major challenges relating to competence and expertise in the administrative justice system?
Thank you for your question. I'm Lori Mishibinijima, everyone. And I'm coming to you from Toronto, which is land that has been taken care of by the Anishinaabe, the Haudenosaunee Confederacy, and the Huron-Wendat, and as well to the current treaty holders, the Mississauga of the Credit First Nation. I promised to try to learn about the laws of your nation and your land and follow them accordingly. To your question, I really like what Marion had to say as well about trauma-informed lawyering and having some of those principles applicable at tribunals and with adjudicators. And I will get into the details of what specific things I think could be done to look towards, incorporating EDI at tribunals. But first, I think the key challenge, and if you read my blog post, you'll know, is that I think that Indigenous laws have been incredibly, obviously disrespected, and Canadian justice systems are not built on anything whatsoever related to Indigenous law and values. It's a major part of this land and territory, Indigenous law, and I think that there is a massive, and this isn't just for Indigenous, but this is for all Canadians. It's important for all Canadians, and it isn't. I think a big part of the problem is that people are afraid to mess it up. They're afraid of the unknown. They don't know what Indigenous law is. They don't know how to implement it. They don't know why it's important to implement. And that's what we have to start addressing with decision makers in Canada. Because they are, interpreting laws of the land, of the people, and that must include Indigenous law. If it doesn't, then you're excluding the very people whose land you're actually on, the resources that made this country. And I think there's lots of ways to do that. And first is learning about Indigenous law and making that mandatory. And the TRC has made a lot of recommendations about including Indigenous and Aboriginal law in practice and in learning. So for instance, with law schools, they recommended mandatory Indigenous and Aboriginal law for all students in Canada, and only a couple of schools have actually implemented that. BC, Osgoode, Windsor, Saskatchewan, Thunder Bay, Lakehead. That's their school. They don't go by the city. And that should be, that is, we're, over 5 years from when those recommendations were made. So a lot of those schools should have been doing that work, should be completed that work, should be on their way implementing it. And same with law societies across Canada as well. The same recommendation was made to them. And a similar recommendation should be made made for adjudicators and judges, that they have to, have an understanding of Indigenous and Aboriginal law in Canada. And because, Indigenous people, not just that, any case involving lands and resources, Indigenous and Aboriginal law should be implemented. So you do have to know, regardless of whether there's an Indigenous applicant or plaintiff involved with your case. The other piece that kind of tags onto that is a similar a similar thing with just EDI in general. Like I talked about in the blog post how Val Napoleon said, we have to stop talking about the why of why we have to include this, why we have to learn it. We have to actually start doing the how, all of us, not just me and other Indigenous people. Everyone in this webinar, everyone on this panel has to do it. And the same is for EDI. I think that there are still lots of places that view EDI as a tag on, even the acronym itself, EDI. Oh, you got your EDI person? Are you hiring your EDI person? Just the fact that you have a specific person that is doing this work and it's not incorporated throughout your whole organization I view that as problematic. And puts a lot of work on, one person or one group of people who are always fighting for EDI. Sorry, it's not like I disrespect EDI. Just the phrasing of it to me is not not respectful to actually the people who it impacts. And it's not, EDI isn't a tag on or something in law that now you have to do. It's actually something that's important for your organization that you have to implement in a way that is respectful of the people who it impacts. And I don't view everyone as in that same boat. Maybe the people here, and that's just also the problem as well, is when we talk about these issues, usually we're talking to a room that with people who already agree with us. And we should be talking to rooms where they don't know what EDI is. They don't know how to implement it. And they maybe even don't want to. Those are the hardest parts. That it rings true when you think about mandatory legal education, especially for Indigenous and Aboriginal law. Not everyone wants to be in that room, and you have to be able to manage those difficult discussions. And I think that doing that work is probably one of the biggest challenges we have for implementing EDI and Indigenous law throughout, Canadian justice processes. I think that's 6 minutes, so I'll just wait to say other things later.
Okay, thank you. Thank you very much, Lori. I really appreciate those comments. And yes, I mean, to speak to your second point, the idea of EDI being kind of the tag on and not necessarily being shouldered by everyone, I think is very challenging and very problematic. And to your first point, I completely agree that we need to think about Indigenous law and how to implement it. And I wanted to just ask one quick question, and maybe you can just answer briefly, and if there's more, return to it later on. But how do you see the implementation of the how for adjudicators for Indigenous law? So how do we train adjudicators to be able to apply Indigenous law?
Definitely you can, get taught it in the traditional way of sitting in a room and an Indigenous law expert, speaking at you. But there, I think, and we are implementing some of this at Osgood, but ways to address different learning styles and the ways actually Indigenous law was taught well, I'll say pre-contact, but even after contact, this is how Indigenous people are sharing their laws and protocols about life and how to live life, basically, is through, life experiences and sharing those life experiences. And specifically, we've been working on land-based learning through our Anishinaabe law camps at Newashming and Rama First Nation. And we have invited judges to our law camps before, and definitely once we are able to have them again, we'll invite quasi-judicial decision makers and judicial decision makers to that process. But like part of like maybe those organizations should be trying to enact some of those learning styles, and with their own funding and their own finding their own teachers in the local areas that they're from or that they're serving, I think is a start.
Thank you, Lori. Thanks for that. And, it really does add an important dimension to the Tribunal Watch statement, I think, in terms of what could be and should be asked for from governments in terms of making sure that adjudicators and tribunals are ready, competent, and expert. So thank you for that. So we've come now to the Doctrinal Law Perspective. And for this perspective, Professor Daly has recorded some reflections that talk about the latest common law as well as legislation. So I'm going to ask if we can start that recording now.
Well, thank you very much, Professor Jacobs, for your indulgence in allowing me to prepare some pre-recorded remarks for this session. I'm very sorry that I can't be there in person with all of you. I have prepared some comments on the black letter law of tribunal competence and expertise, which is a central point in the statement of principles prepared by Tribunal Watch Ontario, and of course the subject of today's discussion. I think the statement of principles makes a very useful distinction between subject matter expertise and competence and dispute resolution expertise and competence. These are distinct and both are vital. In many regimes, competence in dispute resolution, finding a satisfactory conclusion for all the parties, is at least as important as subject matter expertise. In my short time as a part-time tribunal member, I've come to appreciate the importance of dispute resolution, competence and expertise, and indeed marvel at the ability of my more experienced colleagues to navigate the parties help the parties navigate to a satisfactory resolution. I think in turn, I would make a distinction between the law as it requires expertise and competence and the law as it facilitates the development of expertise and competence. Now, if we look to how the law requires expertise and competence, we start with legislation. Sometimes legislation provides directly or indirectly for what might loosely be described as expertise and competence requirements. For example, the Environmental Protection Tribunal is subject to the Canadian, or established by the Canadian Environmental Protection Act, and that requires that members have knowledge of Canadian environmental law. The Competition Tribunal Act provides for an advisory panel of experts in an area who can advise the minister on appointments. But these legislative requirements are pretty loose, if we are being honest about it. In terms of the Environmental Protection Tribunal, the federal court has noted on a number of occasions that the provision requires knowledge, but not necessarily expertise or competence, knowledge of environmental law, but not necessarily subject matter expertise. In Ontario, the Adjudicative Tribunals Accountability, Governance and Appointments Act, TAGA, provides for a member accountability framework, which will contain, amongst other things, a description of skills, knowledge, experience, other attributes, and specific qualifications required of a tribunal member, someone who's going to be appointed to the tribunal. But again, this is a fairly loose requirement, and I don't think anything in these statutory provisions guarantees substantive subject matter expertise or competence in terms of subject matter and in terms of dispute resolution. There's no mention at all directly in these provisions, and this is perhaps an avenue of legislative reform. If we turn to the common law, however, the requirements of expertise and competence are somewhat more imposing. The position of expertise, of course, in Canadian administrative law has been hotly debated over the years. In Vavilov, the Supreme Court took an important turn, taking expertise out of the contextual analysis of the standard of review, and instead moving expertise to a place of central importance, I would say, in the application of the reasonableness standard. That is to say, demonstrated expertise is now baked into the application of reasonableness review. And if tribunal members want their decisions to survive Vavilovian reasonableness review, they have to demonstrate that they applied their expertise. And whereas in the past, Canadian law has been characterized by metaphysical debates about expertise, I think the Vavilovian turn in requiring expertise to be grounded in and demonstrated through reasons makes expertise a more tangible concept and certainly imposes a requirement of competence and expertise if tribunal members' decisions are to survive reasonableness review. In terms of dispute resolution expertise and competence, that's where the common law of procedural fairness comes in. Fundamentally, tribunal hearings have to give individuals a fair crack of the whip. And while tribunals are masters of their own procedure, they're masters in their own house, they also have to respect the rules of procedural fairness. And here, the outputs matter, and rather than the inputs. You have inputs in terms of statutory requirements for expertise and competence, but the law of judicial review, the common law, imposes requirements based on the outputs. Was the hearing fair? Was it run in a competent way in terms of dispute resolution, competence, and expertise? And was the decision the product of demonstrated expertise? These are output-focused requirements rather than input-focused. And I think it is probably fair to say that the common law heretofore has been more influential than statute in terms of requiring expertise and competence. If I turn to the second part of my distinction in terms of how the law facilitates expertise and competence, here I think it's important to point out that statutes and the common law provide floors rather than ceilings, and tribunal appointment processes, training for new members, and continuing professional development can go over and above, and sometimes far over and above, the statutory and common law requirements of expertise and competence. Do statute and common law provide any barriers to the acquisition and development of expertise and competence? No, I don't think so. I think they facilitate it. First of all, when you're appointed to a statutory position, you acquire expertise and competence by working on the job, especially as it relates to dispute resolution. The common law has also been appropriately flexible in terms of facilitating the development and fostering of tribunal expertise and competence. So adjudicative independence is an important common law principle, but tribunals can nonetheless foster internal dialogue and discussion. The consolidated Bathurst decision about plenary sessions of members talk about issues of law and policy. As long as tribunal members are not directed to adjudicate in a particular way by a hierarchical superior, a tribunal can put in place processes for dialogue, discussion, and even internal review of draft reasons and of how members conduct hearings, all in order to foster expertise and competence. And I think the common law does not stand in the way of that, and indeed can facilitate it. So to sum up, from a doctrinal perspective, tribunal expertise and competence are important. Statute is relevant, but in particular, the common law requires the development of expertise and competence in relation to subject matter and in relation to dispute resolution. And in terms of facilitating the development of expertise and competence, the common law and statute do not really stand in the way and do not impose any barriers to the acquisition of enhanced expertise and competence within tribunals. So I would say then that many of the objectives of the Statement of Principles can be achieved by administrative tribunals within the existing framework of black letter law. There's reference in the Statement of Principles to compensation and reappointment. And here, obviously, we have to fall back on legislative intervention, and short of legislative intervention, policy development by attorneys general and by tribunals themselves, advocating behind the scenes for change. We could also, when we're thinking about legislative and political reform and internal reform, wonder about whether requirements of expertise and competence could be set out in statute or in internal policies. And I think in that regard, the Statement of Principles and Tribunal Watch Ontario's work are a very valuable contribution to public discourse. And hopefully in the years to come, we'll have more discussion of tribunal independence as it relates to competence and expertise, and hopefully concrete reforms which will push our system in the right direction. Thank you very much, and thank you again for having me virtually. And I'm very sorry to miss out on the live discussion. Until soon, I hope.
Okay, well, I thank Professor Daly for his comments. I'm sorry he was unable to be with us, but certainly very interesting and valuable points that he's made with respect to expertise, first of all, being kind of baked into, as he framed it, reasonableness review post-Vavilov, the idea of facilitating expertise through the common law. And I like the idea, or the fact that he's touched already on kind of looking at legal and political reform, and even reform within internal policies of administrative tribunals. So these all seem to be avenues that provide some basis, some promise for addressing many of the challenges that we've talked about, perhaps. But I'd love to hear from our guest panelists in terms of what they see as ways to address the challenges. Perhaps it's building on things such as, legislation or common law. Perhaps there are other ways. What do you see? And so I'll turn to Michael again to start us off. Michael, over to you.
Thank you. So I do think that the Tribunal Watch Statement of Principles is important. I think certainly but I would say in terms of expertise, I think building expertise, building competency, capacity involves a number of those principles, not including independence, appointment of chairs, how tribunal resources are deployed, recommendations, appointments, reappointments. And I just want to make one point on the reappointments. I know that the Statement of Principle refers to, robust performance assessment. I think we want to make sure that that's part of a robust professional development, that they're not seen as two separate things, so there's the reappointment and the professional development, particularly if we want to start understanding expertise, as Laurie has said, as Marion has said. We want to understand sort of skills and experience being outside what would normally be or traditionally be seen as expertise or specialized skills and knowledge. We want to understand that we want to appoint, we want to incorporate, we want to accept differing views and ways of knowing, and ensure that that performance and reappointment is supported by understandings that people coming from different areas may need more professional development or career development or mentoring in particular areas. It's the thing about how, what are the performance criteria, and do they themselves create barriers and undermine the possibilities of individuals coming from diverse backgrounds really becoming part of and informing how we see, and the kinds of things we see and understand as merits and building the capacity of the tribunal. And I would say, part of that is, as a tribunal chair, I've seen and I've experienced, the tensions that exist between some of these aspirational goals and the reality on the ground, high caseloads, lower budgets. And it's not enough to simply say, well, we need to be funded better. I mean, yes, we need to be funded better, but that's never going to happen. Or we're never going to have, truly adequate funding, or we don't want to wait until that day comes, because we're going to be waiting a long time. So it's not that we shouldn't ask for it, but the fact is that the tensions arise. And I'll just give one quick example, and that is, when I am often involved in interviewing adjudicators or members for a tribunal, we often have a problem about mediation, and we talk about something happens in mediation and there's a problem arises, and the complainant is upset and say that, well, they just want to withdraw the complaint, and they start crying and they run out of the room, and what do you do? And it's interesting because some candidates will say, well, you go and speak to them and tell them if they need extra time, go away and think about it, go get legal advice, and so forth. And others recognize that, if you have 3,000 cases waiting in the queue, you can't necessarily give somebody all the time they need to think about it. There are institutional tensions. Now, I don't know what the right answer is. But my point is not what the right answer is. My point is, as somebody who's interviewing a candidate, I recognize the institutional pressures, and that may speak to somebody's perspective, right? And so I think one of the things is important to understand, that this is a challenging question that we need to address, and understand that there are real life pressures, and we have to be strategic. We have to move pieces around. Finally, I would say one of the things that I don't know how you would build it into the Tribunal Watch sort of statement of principles is, but what I raised before, what we've seen in the past couple of decades is sort of a reorganization of administrative justice sector through clusterings, amalgamations, administrative amalgamations at the federal level, and so forth. And many of those are not done with expertise, specialization, or capacity in mind. Some of them are. Some of them are just based on administrative efficiencies, which isn't necessarily bad, but we need to think about how those reorganizations can have huge positive potential, but also present huge challenges in building a sort of a tribunal or tribunals with capacity and the competency to serve its target population. Thank you.
Thank you, Michael. That's very insightful and extremely interesting. Yeah, the last piece that you mentioned in particular with reorganization, whether it be into clustering or other types of formations, not necessarily taking into account, I think it's fair to say, all of the issues that need to be addressed. So thanks. And also your example of balancing tensions within the tribunal. I mean, I think that's something that that we don't necessarily think about right off the bat, right? Whether it's as, academics and scholars, or, teaching about administrative law, or, teaching people who are going to be advocates. How are those tensions actually addressed in the tribunal, and how should they be? I think is also something that needs to be really thought out very, very carefully. I'm going to turn next to Marion. From your perspective, Marion, representing individuals from the clinics, how do you think that the challenges you've raised can be addressed? And does the Tribunal Watch statement, take us there, even partway?
Mm-hmm. Thanks for that, Laverne. Yeah, I think I like the statement of principles. I think it's really important to make a direct connection when we're talking about the expertise and competence to make sure that we're including, there's a section in the principles that talks about equity and diversity. And I think we need to make a direct connection there to avoid the possibility that people could see that just as an add-on, as opposed to being an integral part of the expertise and competence that's required. I think when we look at all these issues, certainly there's an opportunity, I think, for the tribunals to take some leadership here, because when the Truth and Reconciliation Commission made came out with their principles, it was very detailed, right? So there wasn't a sector of community that could say, well, we just need to sit back and wait for somebody else to take leadership. There's that obligation, that responsibility rests on all of us. So when I look at that from a tribunal perspective, I think there's an opportunity there for the tribunal to take some leadership in terms of how they prepare their own members and address competency and training, and kind of the environment that they create on that tribunal, because it's very much, I think adjudication is very much a work in progress. You learn from each case that you do. And so you need to have a forum where you can share those experiences with your fellow adjudicators and increase everyone's knowledge and understanding. And so I worry about the pressures that get put on tribunals members to produce decisions, just write decisions or give decisions, and that it takes away from that opportunity to really reflect and share their experience with their colleagues, because I think that's really important. I think there's also obligations on us as advocates for the people who appear before the tribunals to help the tribunals gain that fuller, deeper understanding of our clients' context. And I think when I look back at my time of taking cases before the tribunals, there are definitely times where I felt like my primary purpose in that room was to shield my client from harm that could happen either from the adjudication or from the other side when the context of their situation wasn't being properly understood. And that presented the challenge to help, these parties with such different experiences really appreciate what potential there was to address my client's situation within the law. And so I think that, part of what we encourage at our clinics is this reflective practice where advocates will sit back and look at, what has happened in a case and discuss that with their colleagues so they can have a better understanding of what could have happened, what should have happened, or celebrate the success that did happen and share that experience, right? And it's a time of tremendous, I think, change within our communities, given what we've experienced in terms of the pandemic. We know it has an unequal impact on the clients, certainly that the clinic has, in comparison to the experience of people who have much more income and housing and cultural security. And so, in that context, given the huge concern that we have right now within Canada for racial justice, I think there's an impetus there and an opportunity for us to say, how is it that we do this adjudication work on these really important issues that are affecting people? How do we keep people engaged and believing and upholding the rule of law? And I think that, the answer to that is one of really transforming the system so that there is a place and there is a broader understanding of what the possibilities are for people and how people are able to participate in the hearing. So I think it's a conversation that certainly government needs to take some leadership on. I think the tribunal also has some responsibilities. We have it as advocates, but I also think we have this tremendous community that we can call on to say, help us do this better so that the outcomes that we are achieving for people are much more satisfactory and addressing the issues that they are facing. So that's where I see some of the opportunity.
Thanks so much, Marion. And as you were talking, I mean, one thing that came to my mind is, two things came to mind. One is that it would be a wonderful opportunity, I think, to take what you're saying even a step further and have, advocates and, tribunal decision makers meet to talk about, the ways in which cases could have been addressed, the whole concept that you were just talking about of having to shield your client, trauma-informed practice, whether it's, a practice on the side of lawyers or practice on the side of tribunals. It sounds to me that there could be great opportunities for sharing and knowledge there. The second thing I was just going to say quickly is that, I know that, I've sat on tribunals. I know that there are opportunities and that tribunals take the opportunity to sit and kind of talk to each other about, globally what's going on. And I just wanted to turn to Michael to see if he had any additional thoughts on, whether those opportunities could be fruitfully expanded on to address some of these concerns.
Yes, well, of course, there are opportunities in terms of full board meetings, which or assigning panels. I think both of those things, panels that may have people with different experience, either or different seniority, and so there's a great opportunity to develop expertise and skills and perspectives. Again, it depends on resources, depends on, the tribunal leadership seeing that as important, understanding that as important, both for the particular case, but as in terms of building capacity and knowledge across the tribunal on a longer term basis. The other thing I would say is, certainly when I was at SJTO and the Environmental Land Tribunals, we did have, because of the size, again, there were opportunities, but there may be other ways through SOAR or other, CCAT, there to have professional development where, people like Miriam, come and speak exactly about what she's talking about. Where you encourage people who may be a very specialized knowledge in a particular technical area, to to participate in a seminar or a workshop on trauma-informed approaches to adjudication, even though they do not have much opportunity, or traditionally not have opportunity where they see a need for that. But of course, perhaps they haven't seen a need for that because the tribunal really isn't accessible for people who would need that kind of alternative approach and perspective. So I think through those internal discussions and broader ideas of professional development, there are great opportunities to expand that.
Yeah, I agree. Thank you so much. Thanks to both of you. I'm going to turn to Lori next for a response. Then I'd like to try to answer a few of the questions, or at least a couple of the questions with the time remaining. So Lori, if you could tell us your thoughts on how to address the challenges you've seen and any thoughts you have about the Tribunal Watch Statement.
There, sorry. I'm just learning how to use Zoom. So specifically for Indigenous and Aboriginal law, and potentially also the same goes for EDI. So Indigenous law and Aboriginal law being is currently being interpreted by mostly or would be mostly interpreted by non-Indigenous and settler adjudicators. So that means that there's, potential for those adjudicators, because, we're not all perfect, especially in terms of Indigenous law, that it would be misinterpreted or misapplied. Indigenous law would be misinterpreted or misapplied. So definitely one of the key ways to try to alleviate that is by providing training, mandatory training for adjudicators and judges. And we talked about one way earlier, but the next piece for me is there are very few BIPOC adjudicators and very incredibly few Indigenous adjudicators. So I think that there has to be a lot of work done for recruiting and retaining BIPOC adjudicators, specifically Indigenous adjudicators. And so specific ways to do that, part of it is the justice system. One, there are very few Indigenous lawyers or people with legal training, and I know you don't have to be a lawyer to be an adjudicator, so there should be more work done with non-lawyers to do more capacity building in these areas so that there's a larger pool of candidates. And the work actually has to also happen with tribunals. Tribunals have to build trust and relationships with communities, not only because they're serving them, but also if they're trying to recruit people from those communities to be adjudicators, they still have to build the relationship and build the trust. It's not we're all dying, Indigenous people are all dying to be adjudicators and a part of settler colonial law and, all that decision making that, has nothing to do with how Indigenous people dealt with whatever the dispute is, landlord, tenant, human rights, environmental. Most of the time, the ways that settler justice processes deal with it is very almost the opposite way that Indigenous people would deal with it, or Indigenous nations, sorry. And so I think that also it's important to, when you're connecting with communities, that's knowing where what the local nations are doing in terms of, rebuilding their Indigenous laws and working with them to do that, because Indigenous laws, ceremonies, protocols, languages, children were all stolen from Indigenous peoples. So to expect that they are ready to go for you today and have everything perfectly, lined up so that you can learn it and then apply it is a pretty tall order, and it's not it's not a good expectation to have of Indigenous communities. And I think another way of doing this type of recruitment with BIPOC and Indigenous people in particular is, adapting qualifications to highlight inclusion and Indigenous law and diversity and equity, and making that as a part, just a part of how you hire every single person. And maybe in that sense, Indigenous and BIPOC people will have a chance because the qualifications actually are, matching what equity says should happen. So that is one way. I talked about capacity building. I'm worried about time. But another thing that should be happening as well is when you actually get an Indigenous person hired, or a Black or other racialized person with your tribunal, you have to provide mentorship and a safe environment for them to do their job. One, if they're not safe, they're not going to stay there with you if they don't feel safe. And then two, they're not going to help you recruit if you aren't providing a good mentorship experience for them. It's going to mean that the person is not having a good experience, and they're not going to recommend that their friends then come and work for the same place. So a lot has to happen with the organization or tribunals in areas of recruitment and retention of BIPOC adjudicators. And then also looking to, I think that speaks to the guidelines as well. If tribunals are following these guidelines and incorporating Indigenous law and really looking at how to implement EDI, then you're going to have potentially a safer space for, for diverse people to come do this work, for Canadians, Ontarians, wherever you are. Just looking at my notes here.
Well, Laurie, thank you very much. I don't want to cut you off. We're unfortunately running out of time, but have you caught everything? I know you were taking a look at your notes. Is there anything quickly, one last point?
Yeah, I think I got what is.
Okay. So thank you. Thank you for that. And thanks to all of you. We only have a few minutes left, so I think we should probably more or less wrap up now. This has been a fantastic, conversation or set of conversations. I know that I've learned a lot from these conversations. I appreciate all of the time and insights that you've all provided. So thank you for that. Before we go, I just wanted to turn it over to Brian Cook from Tribunal Watch, who's with us. I think he has a couple of words to say about another upcoming event, and then we will close. So, Brian?
Thanks very much, Laverne, and thanks so much to you and your team and to the panel members today. These issues that have been discussed here today are not just as an academic concern. Some really important tribunals in Ontario have or are about to have a complete turnover of adjudicators in the span of just 3 years. And that represents obviously an enormous loss of expertise and institutional knowledge as well. One tribunal that is of particular concern is the Landlord and Tenant Board, and there's been some comments about that today. And there will be the next webinar that Tribunal Watch is involved in will be on June 14 at 1 o'clock, and that will be on the question of the Landlord and Tenant Board. The title is The Current Crisis and a Cautionary Tale from British Columbia. So please go to our website, tribunalwatch.ca, for more information on that event, how to register, and also watch for the blog posts from these two webinars, and soon a recording of them as well will be available. So thanks again.
Thank you very much, Brian. And thanks again to all of our guests for joining us today. This has really been a fantastic experience. And I'm glad that there's an additional webinar coming up on the Landlord and Tenant Board, which sounds fascinating as well. So I'm just going to wrap up by saying that, I want to thank my team for all of the work that they've done. They've done a tremendous job. And I want to thank the general audience for attending today and attending last week. So thanks to everyone. And we will hopefully see you again soon for another event. Bye.